Honourable Senators, I would like to begin my remarks today by thanking our colleague, Senator Harder, for bringing forward this important piece of legislation and for beginning a conversation that is long overdue and can no longer be ignored. The role of the notwithstanding clause and the need to protect individuals and minorities from governments that would abuse this extraordinary power. Over the course of the last several years, the conventions that had surrounded the notwithstanding clause have undergone a sea change. What appeared to have been a politically self-imposed, decades-long moratorium on this power has come to a dramatic and deeply worrying end. I would concede at the outset that the use of the notwithstanding clause is not unprecedented. Following the proclamation of the 1982 Constitution, the government of Quebec opted to use the power frequently, invoking it in every piece of legislation as a symbolic protest against the Constitution their government had not signed. However, that invocation was universal. It was not directed at any single policy or group. And just 3 years later, a new Quebec government ended the practice. I also note the clause was invoked again in Quebec in relation to French sign laws. Although this invocation followed a fully litigated Supreme Court decision, and the use of the notwithstanding clause lasted only the prescribed 5 years, after which it was replaced by a new law crafted within the bounds of the Charter. There is one further historical footnote to add, which includes the use of the clause by the government of Saskatchewan in 1986 in relation to a labor dispute, which the courts later found to be moot. These 6 early years of experimentation with Section 33 are the beginning of the story. And for many proponents of the notwithstanding clause, they represent the outer limits of legitimate historical use. However, the fact remains that after this brief period, something remarkable happened. We entered a nearly 30-year era during which the clause was left untouched. It was viewed, quite appropriately in my opinion, as a dangerous and regressive nuclear option, always present, always a theoretical threat to social progress and minority rights, but one that governments understood was best left unused. Constitutional scholar Peter Hogue famously described the notwithstanding clause as, I quote, a paper tiger, a dormant power, frightening on paper, but politically untouchable in practice. For 3 decades, that restraint held. Governments of all political stripes understood that to use Section 33 was to cross a moral and democratic line. It was to tell citizens that their fundamental rights and freedoms were negotiable. This informal convention and ensuing political self-restraint represented one of the quiet triumphs of our constitutional democracy. It demonstrated to Canadians that our Charter of Rights and Freedoms had matured and that its guarantees were not only legal principles, but shared national values. Still, for many Canadians, especially those from marginalized and vulnerable communities, the fear of what the notwithstanding clause could be used for never fully disappeared. It was always there, lurking just beneath the surface of our democracy. For 2S LGBTQI+ Canadians, that fear was not abstract. It was personal. It was lived. After the Vreend versus Alberta decision in 1998, when the Supreme Court of Canada ruled that the exclusion of sexual orientation from Alberta's human rights legislation was unconstitutional, there was enormous pressure from conservative factions within the province to use the notwithstanding clause to override the court's decision. Those of us who lived through that period will remember the fear, anxiety, and uncertainty that followed. It was a moment that forced queer Albertans to ask themselves, will my rights be protected by the Constitution or erased by my government? Again, after same-sex marriage was legalized in Canada in 2005, there were renewed political discussions in some quarters about whether the notwithstanding clause could be used to block or reverse marriage equality. Imagine, colleagues, a world where government had invoked this draconian power to block marriage equality and empower gay, lesbian, or bisexual Canadians to be fired from their jobs just for whom they loved. Imagine if these aspects of our pluralistic society that we are so rightfully proud of today had been prohibited by Section 33. In the end, those threats were never realized, but the mere possibility, the fact that such discussions could be seriously entertained, revealed the precariousness of minority rights when they depend on the goodwill of governments rather than the permanence of equality and the fundamentals of human dignity. For years, this was an uneasy peace, a charter that promised protection and a clause that hung like an ominous shadow over those promises. But now, colleagues, the tiger has awakened. In recent years, we have witnessed an erosion of the political restraint that once protected the integrity of our charter. Governments are no longer shy about reaching for the notwithstanding clause, not as a measure of last resort, but as a tool of political convenience. In Alberta and Saskatchewan, we have seen Section 33 invoked to strip away fundamental human rights, block access to health care, and undermine the privacy and dignity of transgender youth, who are among the most vulnerable members of our society. This is not abstract constitutional exercises. It is a no-holds-barred attack with the intent of telling trans children and their families that their identities are up for debate, that their very existence is subject to the will of the state, that their rights are beholden to the whims and will of others. It's all the more cruel and vicious the government of Alberta opted to invoke the notwithstanding clause last week, which also marked the Transgender Day of Remembrance. This day is meant to be a time to mourn and reflect on the countless trans individuals who have been subject to hateful attacks, violence, and discrimination. It was on this very solemn occasion the government of Alberta shamefully opted to double down and further contribute to ongoing discrimination. When a government uses the notwithstanding clause to preemptively shield its legislation from charter scrutiny before a single argument has been heard, before a single person has had their day in court, it is not governing with confidence. It is governing through fear. And when that power is used to target a specific vulnerable group, whether that be trans youth of today or another community tomorrow, it is not democracy. It is majoritarianism in its most dangerous form. The government of Alberta's recent move to invoke Section 33 in relation to labor rights provides yet another warning. When governments begin to normalize the use of the notwithstanding clause, they lower the threshold for its invocation across the board. Pick your issue, colleagues. Pick the charter protections you care about and ask yourself if you are sure they are not next. This is what happens when an exceptional measure like this becomes routine, when the once unthinkable becomes accepted, and slowly the charter itself begins to lose its binding power, not through formal amendment, but through habitual disregard. We must be honest about what this means for the health of our democracy. The charter was not designed to make governing easy. It was designed to make governing accountable. It places limits on the power of the majority precisely because history teaches us that majorities are not always right, and that rights are not truly rights if they can be suspended whenever they become inconvenient. Section 33 was included as a political compromise, a recognition of parliamentary sovereignty within a new constitutional order. But it is not a casual power. It is not something we can afford to make routine. When governments begin to treat rights as privileges, to be granted or withdrawn at will, we risk hollowing out the very foundations of our constitutional democracy. And this is why Bill S-218 is so important. This legislation seeks to restore restraint to our constitutional design and to reaffirm that while the notwithstanding clause exists, it must not be abused. Bill S-218 would limit the ability of the federal government to invoke Section 33, thereby setting a standard that provinces cannot ignore. Just this past month, the government of Manitoba introduced its own bill to place limits on the use of the notwithstanding clause in its own province. Premier Canoe stated, "The Charter contains fundamental freedoms, and it's the responsibility of all of us to protect them." Bill 50 would require that any proposed provincial legislation invoking the notwithstanding clause would be required to be referred to the Manitoba Court of Appeal within 90 days. This would ensure the court has the ability to issue an opinion on the constitutionality of any law, which provides for accountability to the people of the province. To conclude my remarks, I would like to return to the human dimension of the debate. At a time when hate crimes against US LGBTQI+ people are rising in Canada, and when misinformation and moral panic are spreading with increasing rapidity, the use of Section 33 to suppress the rights of trans and gender-diverse Canadians does not just fail the Charter, it fails the test of whether we are a society that protects the most vulnerable. History will judge us not by the powers we possess, but by the restraint we show in exercising them. The choice before us is not about federal versus provincial power. It is about whether our laws will defend those most in need of protection. It is about whether we allow the Charter to remain the shield it was designed to be, or we let it become a set of perfunctory principles subject to the political whims of the day. Bill S-218 offers us a chance to draw an important line, to reaffirm that rights are not bargaining chips, and that governments must never use constitutional loopholes to silence or scapegoat their citizens. Colleagues, Canada's diversity is a source of our nation's pride and our promise. What makes our nation so extraordinary is how we have made our multiculturalism and pluralism into a defining strength. The notwithstanding clause was meant to coexist with the very principle of pluralism, not to undermine it. But today, we must recognize that the balance has shifted, and without legislative action, the misuse of Section 33 will continue to expand, eroding the very moral authority of the Charter itself. This is why I strongly support Bill S-218. It is a measured, responsible, and necessary step to protect the integrity of our Constitution and to reaffirm the primacy of human rights in Canadian law. Let us not wait until more harm is done. Let us not tell future generations that we saw the warning signs and did nothing. Let us remember that silence makes us complicit in the very act of discrimination. Let us act as senators, as defenders of the Charter, as Canadians who believe that equality and justice must never be optional. In many ways, we are not only a chamber of second sober thought, but the holders of Canada's conscience, and if need be, the defenders of democracy. Thank you, honourable colleagues. Merci. Medway.
Sénatrice Miville-Deschênes.
Senator Miville-Deschênes. Will the senator take a question? I will be asking it in French. I agree with certain parts of your speech. However, I'd nonetheless like to speak about something that bothers me as a Quebecer in a bit of your content. The fact that we're preventing teachers in schools from wearing a headscarf does violate Charter rights, and the use of the notwithstanding clause is questionable in that case. You did, however, mention an example used by Quebec that has received unanimous support in the province. It was broadly accepted. The idea that we have this advertising law. We absolutely had to invoke the notwithstanding clause, and of course it was the majority against the minority, but Quebec is linguistically a minority, and so Quebec used the notwithstanding clause to protect its language. This is something that cannot be put on the same level as all the other examples you gave. Senator Wells.
Thank you. Thank you for that example. I would certainly agree that at times it could be appropriate to use the notwithstanding clause. I think where I become most concerned is when it's focused on taking away fundamental human rights from vulnerable Canadians. And given the examples that I provided of what's currently happening in Canada. Thank you for the question.
Senator Batters, Senator Wells, the time allocated to your speech has expired. Are you asking for 5 more minutes?
5 more minutes, please.
Do you agree, Senators? Agree. Senator Batters.
Thank you. At the end of your response you just gave to Senator Mavell-Shane there, you indicated that potentially would have been one of the example she gave would have been one of the situations in which you would consider the notwithstanding clause to be correctly used. Would you consider the example that is actually the impetus for this bill, the mandatory, the consecutive sentences that a murderer in Quebec was given by murdering several Muslim men as they prayed in a mosque? That was the reason that the notwithstanding clause was potentially going to be used by the Conservative Party had we won the last election, to provide that would have been an acceptable time to use the notwithstanding clause to allow someone to receive more than just the one, I believe it was a 15-year sentence for murdering multiple Muslim men who were there to pray.
Senator Wells.
Thank you for your question. I think that simply because we disagree with a court decision doesn't mean that the only option available is the use of the notwithstanding clause. Again, we went through a 30-year period where governments responded to different judicial rulings in a variety of ways without the need to resort to that power. You know, in fact, given some of the concerns that have been raised today with some of the decisions of the courts, certainly regarding child pornography as a recent example. For example, Minister Fraser has been quoted in the newspapers saying just even today that the government is prepared to address the constitutional issue, ensuring that there are consequences for offenders. So I would say that it's important that we actually let the courts rule on the constitutionality of the issues and then look towards the government responding.
Senator Batters.
But in the case that I cited, there's no easy solution. You have someone who's convicted of multiple murders, and they're basically getting a volume discount because there's only the opportunity to have the sentence that's given for, I believe it was a second-degree murder, is a minimum of 10 years without possibility of parole. So this is not the sort of case where there might be an easy fix. There isn't an easy fix. In this case that was presented during the last election, that would have been, the notwithstanding clause probably would have been the only legal case. And I say that as a lawyer and someone who actually thinks about these kinds of issues. So if you have another solution for that, I'd be anxious to hear it.
Senator Wells.
I can assure you, too, I think deeply about these issues on a personal and professional level. I absolutely agree that we need judicial reform. We need reform to the criminal code. That's why I think it's important that we're seeing C9, for example, coming forward for us to be able to debate, to have better tools to address the issues we're experiencing today in society. And I think that's a really important job that we serve in this chamber, is to scrutinize those laws and ensure that not only are they charter compliant, but they're the best laws we can produce on behalf of Canadians.